could I invite Professor Michelon to deliver his inaugural address entitled A Value for Private Law.
Imagine that a few years from now, the excesses of late post-industrial capitalism come home to roost. After the ninth of the progressively more severe global economic crisis, the leaders of the last nation standing, the last one that has not descended into chaos, they decided enough is enough. They believe that, rightly or wrongly, they believe that the root of the problem is the practice of recognizing allocations of particular goods to particular people. They know that that's not pervasive. The air they breathe is still not being privatized. Even at that stage of late capitalism, the parks, there are a few public parks left and they're still not privatized. They don't belong to anyone. They haven't been allocated to anyone yet. But many goods were. Cars and factories and farms. And they think, again, rightly or wrongly, that that's the mistake. That's where it all went wrong. Accordingly, they decide to rebuild society, what's left of it, on the basis of no allocations whatsoever. In fact, they'll probably leave, or they're proposing that the community, the members of the community, live much like medieval Franciscan monks thought that they should live. It's not without plausibility to say that medieval Franciscan monks more or less built the modern idea of a right, precisely to say that they had no right to private property. They could leave evangelical poverty without having to walk naked in the streets. They could still use their gowns and their clothes and sandals, famously. They could do all that without owning anything, without having property. So perhaps the leaders of this last remaining community standing, they're proposing something like that. And accordingly, they decide to take matters to law. First thing they do is to abolish all title to anything. Not only what we narrowly consider as property, but anything. Everything is going to be owned, every right is going to be owned jointly. Or if you want to be more radical, there are going to be not even joint ownership. There will be no ownership. Nobody will own nothing. The second step, of course, is to abolish all the rules of acquisition of title. There's no point in actually abolishing the titles and then allowing people to steal by occupatio or by specificatio to acquire more property. So all those rules have been abolished. They've been written off the law. They are now consigned to legal history books. Soon after, they start perceiving shockwaves across the legal system. First thing they notice is that there's hardly an opportunity to apply any rules of the law of delict or tort, because it's not that people became angels after allocations. They still harmed other people and destroyed things, but if they have to pay an indemnification, where are they going to draw from? They haven't been allocated anything. Also, plaintiffs are not going to be able to own anything, so what's the point of actually winning a case like that? Certain contracts, and that goes for liability and for wrongs, but both contractual and non-contractual, but certain contracts themselves has become pointless. How are we going to sell goods, or other agreements as well, or how you are going to barter goods if you don't own anything? And the ripples spread across private law. Unjustified enrichment, again, more or less disappears. Think about enrichment for transfer. Or by transfer. So you have no transfer of goods from one state to the other because there are no states. So our community now lives without allocations. Now, I don't think that is feasible. But the point of trying to start with that is trying to show you what I believe to be a key feature of private law that I'm going to try to unpack throughout the lecture, the centrality of allocations, of which, of course, the paradigmatic case of allocation is the allocation of private property, but not only. It can be allocated privately certain other positions, Hegelian positions. So allocations seem to be so central, and yet, when you talk about the value of private law, the discussion about how we assign value to particular allocative schemes rather than others, which allocative schemes to prefer, seems to go amiss, or seems at least not to be present. So what I'm going to do now is to try to put forward a particular conception of how the value of private law institutions, I'm going to use the label generically private law institutions. I know, and I'll point that out as we move along, that different private law institutions are going to have value, or value is going to supervene on them in different ways. But a private law institution is going to be used as just a term of art to refer to an umbrella term, to refer to all those institutions we're familiar with: property, contract, delict, law of delict, unjust enrichments, and so on. So there's a way in which value supervenes on those things that is directly connected to a proper, or understanding how value accrues on them or supervenes on them it can only be properly achieved if we are attentive to ways in which we justify allocations of goods. That's complicated, so I'm going to unpack that. Actually, the whole lecture is to unpack that, trying to unpack that idea. So, let me first give you a sense of the landscape of the reflection about the value, the justifications for private law institutions that we have now. I'm not going to go into details. I'm going to basically classify them in two basic groups. And most theories about why private law is valuable are going to fall, I think all of them are going to fall in either one or the other group. So the dominant theory, or the dominant conception of the value of private law, is still some sort of instrumentalism. Law is valuable because it's a means to an end, it's an instrument to achieve certain goals. And private law is also an instrument to achieve certain goals. In fact, instrumentalism has not only been put forward as a good way to explain private law institutions, but law in general. Les Green published a paper a few years ago in which he said one of the few things in which everyone agrees is that law has instrumental value. And so everyone agrees that some instrumental value should be assigned to everything in law, says Les Green. Says natural lawyers talk about the common good as an end that law has to help achieve. Law and economics scholars talk about, I don't know, well, many things, but one of them is the maximization of wealth, another goal, and so on. So there seems to be a more or less pervasive agreement that law is somehow functional. And of course, in private law, we see a lot of that. We see a lot of that both in terms of general theories, like law and economics, but we see that in particular institutions as well, when people try to explain why a certain feature of tort law or delict law has come to prominence. We try to find out why the function, what kind of good is served, what kind of value or purpose is served. And those values are external to the institution. So we try to prevent harm, for instance. So it's one way in which we prevent harm. And that's why we have the law of wrongs. We try to give negative incentives to people. So some people would say that that's one natural, most people actually probably would say that that's a natural way to think about the law. It's still, I think, the dominant way to think about the value of law and private law. But if you know the literature, you see that you know that in the last 25 years, 30 years, voices have been, especially in private law, voices have been raised against functionalism, or against the idea that private law should be justified on the grounds of an external purpose it fulfills. Private law has an internal purpose. Private law shouldn't serve other ends. As Ernest Weinberg put in the idea of private law, which was, I think, it's now 21 years old, the function of private law is to be private law. There's no external function. There's no external. Now, put that way, the distinction is a bit awkward. It's probably not very easy to understand how that could be a distinction. For starters, I don't see how you have to make it, why you necessarily have to, in the absence of further argument, you have to make a choice. Why something couldn't be intrinsically valuable and also instrumentally valuable. So pitching one against the other as exclusive ways to produce value seems to be awkward. So for instance, and that both is a pervasive feature of many ways in which we think of moral reason. So think about, say, Kant's second formulation of the categorical imperative. which is probably, so this is the Kant's fifth formulation of categorical imperative by Claudio, but act in such a way that the humanity in others is treated not simply as a means, but also as an end in itself. The idea is that clearly you might treat humanity in others also sometimes as a means, and that in its might not be a problem, provided that it's a means to an end that's intrinsically valuable. So that seems to be a pervasive feature of our moral discourse even. Moreover, I think if intrinsic value theorists like Weinrib, Ripstein, and others, if they adopt this radical version of one or the other, they lose a lot of plausibility to their thesis, because clearly, even if they can prove the private law institutions, and they focus a lot in the law of delict, torts, even if they're right about that, it's very difficult to deny that, at least in some situations, some rules, or some central concepts and rules of, say, delict law, which is what they focus on, they don't have also instrumental value. I mean, think about this. If in a particular society, the law of wrongs also happens to provide negative incentives to conducts that are considered to be harmful or bad, that's not outside the realm of probability. You'd have to make a huge sociological commitment to say that that's never the case. And to say that preventing harm is not valuable, again, it depends on huge, well, not huge, but an immense effort for it to prove that preventing harm is necessarily not a bad thing. And I think that that's, if they believe that, if they believe in the exclusion, there's something that would be implausible about the whole conception of private law serving internal purposes. So, applying charity, they cannot be thinking that. They might be thinking something else. I think, and they showed that in some publications, they might be saying something like this. Yes, there might be different, value might be in different ways on private law institutions, but when we are called to interpret the law and to apply the law and to develop the law in law reform, we should think primarily on private law's intrinsic purpose rather than the extrinsic purpose. And you see that in sometimes, I think, Weinrib published that, The Passing of Paul's Graph, sort of trying to, well, you see, here's functionalism creeping into a very traditional private law internal value doctrine. So you see, so they do seem to behave that way sometimes, to police legal interpretation and legal development from the point of view of the particular value they favor, without denying that the other one might be relevant as well. But still, what you need then is to give me good reasons to favor that particular idea of intrinsic value. Why would intrinsic value be, at least even in principle, a better way to go about deciding how to develop or interpret private law institutions, rules, and concepts, sources? I think there are two reasons that are often given. A lot of what I'm going, one of them is given indirectly, the other one is explicitly given. I'm going to mention the two, and I'm going to focus on one. Right? So one of them, the one that is mentioned explicitly, is this idea of coherence. And again, the focus here is in the law of delict, on tort law. The idea is basically this. Well, functionalist explanations can explain one side of the private law relationship. Can explain, for instance, why we want to have certain wrongs and why some people have to pay damages, why that duty is there, and it's because we want to prevent harm or because it's economically more efficient. But there's no reason, they say, why that reason at least doesn't imply anything about paying damages to plaintiff. You could give that to a fund. You could create a sort of system of insurance, compulsory insurance. There's no reason why that particular duty should be connected to the right of the plaintiff. And the other way around, there are some explanations that explain why the plaintiff should have his share of the social wealth, say, restored, because it's unfair if the plaintiff loses it for a certain number of reasons. It's unfair if the plaintiff doesn't have it. But again, it could come from public law. It could be bestowed by a benefit system. It doesn't need to be plaintiff or defendant to give the money. So what they say is, well, our theory the theory that private law has intrinsic value can explain both. The same reason is going to justify both right and duty. It's going to explain what they call correlativity. Now, I think that there are many, many problems with that sort of approach. But that's not the reason I'm going to focus on. Right? So I'm just giving you notice of that. The other reason to give, and that's more indirect and it's suggested more than explicitly stated, although sometimes it is explicitly stated, is that if private law is only valuable functionally, but not intrinsically, only valuable for its relationship to the furthering of external purposes rather than having internal purposes, private law is not really necessary. It's an instrument that could be replaced by something else. So there's nothing distinctive about the way in which value supervenes on private law institutions. And there's nothing distinctive about the way in which they generate value. So think about other instruments. As soon as, I don't know, think about a hammer. Hammers are becoming obsolete because now you have these pneumatic things that are called hammers as well, but they are no resemblance to, they're closer to guns. So it's conceivable that hammers' time is past. So contingent factors might actually make something that's an instrument completely obsolete. And they resist that. They think, well, there's something more resilient about private law than being a mere instrument. There might be changes from one system to the other, there might be changes from one time to the other, but there's something more resilient that has to be explained. It cannot be simply that it's just like a piece of technology that we can do away with. And of course, they are opposed by people like, well, many people, but Richard Posner, who famously wrote a book called Overcoming Law. Law is a sort of something we need to have now, but in the near future, as soon as technology evolves, we can do away with it. In particular, tort law, I think. They think that a sort of complete insurance system would be enough. So what they believe is that if you are an instrumentalist, if you believe that value supervenes in a private law institution because it relates to an external purpose in a particular way, you cannot find anything distinctive about private law. Private law is, the way in which value supervenes on private law is not distinctive. So this lecture is trying to prove that that's wrong. I'm going to try to say that it's true that you can conceive certain private law institutions, at least. And that's all I need, because their thesis is about all private law institutions. So all I need to prove that to prove that they're wrong is that some private law institutions don't behave that way. So some private law institutions, they are valuable instrumentally in a way that is, to lack of a better word, unique. A way that cannot be easily or at all replaced by any other institution. Now, that would require some redescription of some of those institutions, but I think that's a fair move, so I'm going to try to go to that. But that's the main contention. Is that clear? There are institutions in private law that can be instrumentally valuable and still unique in the ways they contribute to the generation of value in the world. Right, as I told you, the touchstone for the lecture, the idea that's going to guide us throughout the argument is the idea of an allocation. Yeah? So we might as well just clarify what I mean by allocation here, and then we can move on with the argument. An allocation is the establishment of and the establishment does need to be, is a relationship that exists between a particular good and a particular person, right? So what you have here is a particular relationship. So the first thing to clarify is which kind of relationship that is. I think that there are many kinds of relationships that could be called allocative in some sense. So I'm going to choose one that is the one that helps me prove my point, and I'm going to tell you what that one is. It's a relationship that is often referred to in the literature as a sort of relationship of power. So the person has power over the good, has control over the good. It's the ability to control an asset. I think that needs a bit of unpacking because it looks like it's a descriptive thesis about the world, that some people have actual control over some goods. And that's not what I think is captured by the idea of an allocation. If for no other reason, because we have very little control over goods, and often we don't control floods and accidents, and certainly I seem to have very little control of the physical well-being of my phone. So control here seems to be overstating the position of the allocatee. So I think the best way to do that is to think of a normative position. And I think for our purposes here, I think one plausible way to think of a allocative position is to think of that in terms of Feldrian positions. So what you have is a combination of two positions, yeah? You have a liberty in relation to certain actions, to perform certain actions in relation to certain good, which is opposed to everyone else. And that's combined with no one else having that liberty. And no one else having that liberty, of course, as you know from your Hofeld, means that they have a duty. They're under a duty not to. So they don't have the liberty. You're not under a duty not to. So the combination of those two positions is a very simple schematic way for me to move along with the argument. Is that clear? So just there are certain actions in relation to certain goods that I don't have a duty not to perform, and other people have a duty not to perform. So, the second point that is important to know in clarifying what I mean by allocation is that so far I've been preying on a sort of pre-theoretical understanding of allocation that could mix legal allocations and moral allocations. So at this stage of the argument, my worry is moral allocations, which means relationships of that kind of liberty that obtain between a person and a good for moral reasons. Not for legal reasons. Law is not in the picture yet. So the whole point is to see what law can do to that. But so far, we're talking about a moral liberty I have in relation to certain goods. Very well. So my worry here is this. A theory of justice, a theory of the right way to allocate goods, to bestow, a theory that tells who should have what morally, can be constructed on the basis of a number of criteria. And if I'm right, some of those criteria are of a kind, I will call them allocation neutral, that require law. So one of the ways to understand what I'm saying here is that contrary to the funny way sometimes in which natural law is portrayed, that law has to be moral to be law, a requirement for the validity of law, and that's of course not what most natural lawyers say, but a requirement for the validity of law is that it's morally sound or not unjust or not extremely unjust. Contrary to that, not contrary, but in a reverse of that, I think that there are some moral institutions whose realization in the world is necessarily mediated by law. So law is a necessary condition for certain moral value to accrue in the world. Not just contingently valuable, but necessary. If I'm right, I'm going to have proven that, but that's for later. Allocations then are those positions of liberty, moral liberty. Now, it's not entirely clear that we should allocate goods at all. That still needs some moral argument. There might be theories of justice that say that we should hold everything in common. Perhaps the imagined community at the beginning of the lecture would find some moral theorists who can produce a great argument to say that everything should be held in common all the time, and create some, I don't know, administrative law rules about first comes, first served in relation to, like we do in parks. You occupy a plot of land because you arrived first, and your barbecue is going to take precedence over someone else's barbecue because you've just arrived first. Perhaps that. But it's not very clear that you should allocate. Sometimes we hear arguments for allocation, like, all that family of arguments about the tragedy of the commons. Having things in common, nobody takes care of things, so we have to allocate things to people so they can be more careful and so on. and sometimes more specific arguments like Locke's or Kant's theory of private property. Now, assuming that we are working within the framework of a theory of justice that requires allocation, so that's an assumption from now on, the lecture. Not a very implausible assumption, I think. Some theories of justice at least require that, most of them require some allocation. The next step, the next question we have to ask ourselves is how to allocate goods. And criteria for allocation are legion. You can allocate according to need, to each according to their need. You can allocate according to equality, to each the same. You could have a sort of roles inequality, to each the same, provided, but you can allocate unequally, provided that the inequalities for the benefit of the worse off. You can allocate goods in a way that Kant or Locke allocates. There's a special relationship that I have with a particular good, and that becomes mine because I labored the land, or it becomes mine because I occupied the land for Kant. So those theories are legion. So it's not going to, so I feel tempted to say, so we're going to go through all of them now, but don't worry, we aren't. What I'm going to do is to group them in two basic groups. And each group is going to be predicated on a particular feature, particular property. And that property is the key to understand why you think value supervenes very distinctively in certain private law institutions and necessarily into some private law institutions. One of them is going to be called, they are criteria to justify allocations, right? The first one is going to be called allocation-bound criteria to justify allocations. The other one is going to be called allocation-neutral criteria to justify allocations. Probably the best way to start showing that is just to give you an example of the allocation-bound criteria to justify allocations. So suppose that you accept Locke's theory, the labor theory of the acquisition of private property. Remember, property for Locke is a moral right rather than a legal right. Locke comes much later. You have property way before Locke comes into the picture. So the way in which Locke justifies it, if you remember, is very simple. If there's a good there that doesn't belong to anyone, and I go there, say an apple in a tree that doesn't belong to anyone, and I go in there and pick the apple, I mixed my labor with that apple. Somehow, my personality now transformed the world. The world, that part of the world, has been contaminated by myself. And as I own myself, I have a right of self-ownership, I now own something that's been contaminated by my personality, by myself. So I'm not going to defend or attack the argument, just to give you a sense of the argument. So what you have here is this idea of mixing labor, that one particular person mixes labor with a particular object, and that, it's interesting, that's not only a reason for that person to have the object, it's the only reason for the person to have the object. There's no reason to establish rights to private property without the first person picking the first apple from the first tree. Hence the importance of Adam and Eve. So they establish a system of private property. So the idea here is basically this. You have a criterion for allocation, but that criteria gives you not only a justification for the allocation, but a justification that is already bound to a particular allocation of a particular good to a particular person. Yeah? Same thing goes for Kant's theory of property acquisition in the metaphysics of morals. I think it's more like occupatio. Lawyers would see that as closer to occupatio than specificatio or anything like that. So you basically occupy, take possession, and there are some conditions for that to happen. Nozick. Those are examples of allocation-bound theories. Interestingly, Jerry Cohen has this insight, which is brilliant, that most Marxist movements, not Marxist theories, but Marxist movements, they seem to rely on exactly the same idea that Locke and Nozick relied on. So the reason why the capitalist is wrong is because I produce the thing as a labor, it's my labor that's been deposited into that object, and then the capitalist comes and takes that away from me, gives me a pitiful amount of money, and then sells it on and makes profit. So again, ironically, the libertarian argument and the Marxist movement, underlying argument, seem to go hand in hand, this idea of a labor theory. But that's not the only way, the only kind of criterion we have. There are other criteria, and I call them, as I told you, allocation neutral. They justify the allocation, but they don't give you a specific matching between a particular good and a particular person. So think about Rawls's criterion, the difference principle, the first part of the difference principle. Everything should be, all the wealth in a particular group should be shared equally, unless the inequality benefits the worse off. Now, I don't know what is going to be allocated. This criterion doesn't tell you whether Eric is going to have this particular jacket or whether George is going to have this particular tie. It doesn't tell you specifically anything about that. It tells you that given a certain system of allocations in place, a certain amount of a certain good has to be allocated to each person. So you realize here there are two ways to do it. One of them is to do it by kind of object. So think about this. I might go to the toy shop with my children. And if I go to the toy shop with my children, I might tell them, you can have this Lego set and you can have this Lego set. And that's matching individual people with individual goods. But I might use as a criterion something like this. Here, you can have any Lego sets within a certain range of price. So now, I don't know which, they might even be identical, but I don't know which one is going to belong to each of them. Some other step needs to be taken. Same thing goes for, and it could be one step further. So this is kinds of goods, yeah? So I could have a criterion of distribution or location that doesn't even refer to types of goods, but to a share, a property that's shared across goods. So something like a common denominator, wealth, market price, value. I can tell my children, I don't care what you're going to buy, provided you don't spend more than £15 in this shop. So that's not a type of good. There are different types of goods, but it's a measure of value, of the relative value of the goods. In all those allocation neutral criteria, what I mean by allocation neutral is not that they are neutral between different allocations. They, of course, justify some and don't justify others. But they don't bind you to any particular allocation. And in fact, if you don't have another instrument, or another means to assign goods to people, you cannot fulfill the criterion. So that's a problem. Now, if you, one way in which you could go about trying to solve the problem is to go to other moral criteria, or still in the realm of morality, yeah? You can go to other moral criteria that are not the particular distributive or allocative criteria that we're using. You can talk about other values, other goods, and you can use those to decide which particular chair should go to each particular person. But quite honestly, I think that's it's a very implausible way to go about thinking about that. The transaction costs are going to be immense, but it's not only that. I'm not entirely sure the moral reasons can be as granular as that, as to say that that chair should belong to me and that chair should belong to. Assuming that, and that's an assumption, perhaps I'm wrong. But I think it's not an uneducated assumption to make. The moral reasons, they run out sometimes without allocating each particular good to each particular person. In the absence of that, we need another way to allocate things. For the criteria of justice that we're talking about to be able to do any work. Luckily for us, there are other ways in which we allocate things to people. We allocate things to people, for instance, by law. There are certain legal rules and legal criteria that we use to make the matching of a particular person to a particular good. We do that. Actually, a lot of property law is about that. It's about who owns what, and how to match people with goods. But not only property law. I think I'm taking a wider view of this idea of entitlement. Now, if that's correct, and I'm coming to the end of the lecture, so don't worry, it's another 10 minutes. And if that's correct, let's try to see how value can supervene on allocations that are allocation neutral, and how value can supervene in allocations that are allocation bound, criteria that are allocation bound. Actually, on private law institutions in relation to criteria that are allocation bound and allocation neutral. Just one, I forgot something, one small observation before we move on to the value part of it. A theory of justice can adopt one kind of criterion, say lock. That's the only way in which you acquire property. One or the other. Or can create a hierarchy for different sorts of, the criteria could be combined. So I'm not proposing that allocation neutral theories are better or worse. I'm just saying that those are criteria that are out there. And provided you don't have a complete theory of allocation, or the value of allocations that are purely based on allocation-bound criteria, a problem for allocation-neutral criteria ensues. How to make the allocations. One of the solutions is private law institutions. Now, let's think about allocation-bound, the way in which value supervenes on private law institutions if an allocation-bound criterion is used, so the Locke's labor theory. Now, I know in those theories who has a moral right to what. Those theories give me a precise answer. I might have some factual ignorance. I might not know who makes the labor, so there might be some proof, evidence to be produced. But if I do have the facts, and if I do have the criterion labor mixing, I have the particular allocation. So private law institutions, including the ones that provide legal allocations, those private law institutions are just means to protect the liberties that we assigned. They're means to ends. We protect that. They're instrumental. And not only they're instrumental, the property on which value supervenes, the property the private law institutions have, is the ability to be causally connected to a particular state of affairs, which is all those liberties are respected and people don't interfere with each other's liberties and so on, the ones allocated. So, in this case, we have a purely instrumental connection, and because there's nothing else law can do, you already have morally who has what. So you have a purely instrumental connection, and the property on which it supervenes is this causal connection. And because it's a causal connection, it's of course contingent. It depends on is there another means for us to protect those allocations? Perhaps a complete criminal law in a totalitarian state is going to do a better job. I don't know. But agent-neutral criteria or value supervenes in private law institutions vis-a-vis agent-neutral criteria in a different way. Also in the same way, they can be instrumental and causal in that way. But there's another way in which value supervenes. Without certain private law institutions, I don't have any allocations to judge by the criteria, the allocative criteria. The criteria themselves are inert. So I need something like those private law institutions. Now, there is some leeway. So, for instance, specificatio is one way to acquire property, to assign property in most civil law systems, in Scotland, if I'm not mistaken, not in the common law, if I'm not mistaken as well. I know less about the common law than I know about mixed legal systems, and less about mixed legal systems than I know about civil law. So that's the scale of my ignorance just displayed. But the idea is there's some leeway. What the criteria are is going to vary from place to place, from time to time probably. There might be better and worse arrangements, but you would need some criteria. So what you need is a set of authoritative, positive criteria. And that's exactly what those private law institutions produce. And without authoritative, positive criteria, there's no way for the allocation to be judged as good, because there's no allocation. The object's not there. So, there you have it. Assuming that we are working within the framework of a theory of justice in which allocations have to be made, and that at least some of the criteria in this theory of justice are allocation neutral. Private law, the value supervenes in private law in a way that's distinctive. This cannot be performed by any other institution. You need those authoritative criteria. Again, it varies from country to country what criteria you're going to use. Specificatio might be used in some countries and others, but we need those authoritative criteria. And without those authoritative criteria, nothing can be judged as being allocated at all. Justice, I promise you that, and that's my delivery. Justice requires law. Now, allocations, I told you, are multifaceted. And okay, I just picked one way to allocate things. I picked liberties, yeah, or fulfill the positions. So the substance of the lecture is finished, but now I have to allocate blame. And that's another way to allocate things. You've been subjected to almost 45, 50 minutes of me talking continuously to you in a relatively stuffy room, certainly too hot for someone wearing a gown. And there are people who are responsible for that. I'm partially to blame, of course, but not totally to blame. So I'd like to allocate some responsibility to a number of people. So of course, and I say that, of course, my parents who helped me throughout my career, but my father invited me to my first law lecture when I was 11, the law of succession. I never touched it again. But it somehow planted a germ there. So you're always learning things about your colleagues that you don't know. So that was my first class. And I asked the question. I was really obnoxious. Yes, it was about the line of succession. It's almost mathematics, so it was okay. They're very condescending, but you know, anyway. So also, the fact that I actually have some time and peace of mind to write lectures like this is to do with the fact that my family helps me a lot. My wife, Lila, and the kids, they help me immensely in everything. So they are responsible as well. The kids less so, they actually... But I think I should allocate some blame on the sort of self-realization they bring. More to the point of the lecture, I've been thinking about things like that, legal theory, and there are traces of people in the lecture. There are traces of periods of my intellectual development. And it's funny that the fact that it's about the value of private law has to do with both the environment, the immediate environment I have in Edinburgh, which is pregnant with private law. And I'm very, very, not only happy, but proud of being in a place like that. But also in journeys that I took with friends of mine like George from the time we were doing our undergraduate degree. We started having what is called in the continent or in Brazil, general theory of private law in the first class with the worst professor I've ever had. And that left a mark. That left a mark. And we were there. And you were there. So George, and standing for all these people who helped me, is also to be thanked. More specifically about legal theory, as Neil said, I was here between 96 and 2000 to do my PhD. And I was more in touch with legal theories than anyone else in the law school. And having been part of that group with Neil McCormack, whose gown this is, Emilius Christodoulidis and Zenon and Burkhardt, having been part of that group was it's unthinkable what my life would have been had I gone elsewhere. And I cannot think of a better life, intellectual life, than here. And in fact, so I do have to allocate blame to Neil McCormack, who sadly is not here, to Zenon, Burkhardt, to Emilius. And then when I came back here, I was a bit apprehensive. In 2007, I had such a great experience during my PhD with my colleagues as well, Fernando and Manolis and George. I had such a good time that I thought nothing that I meet is going to measure up. And it does. The people I work with now are people I enjoy immensely working with. I learn every day. So Neil and Luis and Ewan and Burkhard still, they are an immense part of this lecture, whether they want it or not. So those are the allocations that I had to make. They are to blame. I'm just partially to blame. And I'd like just to thank you for your patience. I have to allocate my thanks to you for sitting here for over 1 hour. Thank you.